everybody. This is Whitney O'Reilly. Today, we are going to talk about grantor trust. So Trust Planning 101, grantor trust versus non-grantor trust. I'm going to give everybody a little bit of time to hop in before I get started on this presentation regarding grantor trusts. We're going to spend just about an hour talking about what a trust is, why we have a grantor trust, what the differences are between a grantor trust and a non-grantor trust. Through this presentation, I'm going to have a couple of questions. A lot of people who come to my monthly webinar know that I love to give out prizes. If you were able to answer a question and get it correct before the other person, we will send you a gift. We do have your contact information. Hopefully that means you listen a little closer. Again, I enjoy spending this hour with you. Feel free to grab some lunch, grab a cup of coffee, and we will dive right in. Just to let everybody know as they're coming on, most of us understand these online platforms. If you have a question, there's a Q&A box. Certainly put that question in there. If I am able to, I will answer that question if I think it is pertinent to the group. If it is specific, or let's say it's off topic, I will try to answer your question afterwards. I'm going to share my contact information with you, but remember, just type my name in the internet and feel free to shoot me an email if you have a question that I haven't answered. And so we've spent a couple of minutes. So I think we are going to get started. It looks like the participant queue is kind of slowed down a little bit. Again, today we are going to talk about trust planning 101. This is in this series where we're talking a lot about trust. What is a grantor trust versus a non-grantor trust? So first, who am I? My name is Whitney O'Reilly. I am the Wealth Preservation Chair here at Cohen Seglius Law Firm. We do estate planning, estate administration, trust planning, and trust administration, and estate and trust litigation in all states that we represent. So we are along the Northeast. My home base at the moment is Philadelphia, but we have offices in New York, New Jersey, Delaware, DC, and I've probably forgotten some additional ones. We just started a practice group in Florida. Today, mostly I'm going to speak about the federal overlay, but I'm going to sprinkle in maybe some Pennsylvania, maybe some New Jersey. So it doesn't matter where you've come from. This information is really important no matter what. I have been doing this estate work for the last almost 20 years. I was just saying at my screening when I hopped on, I'm starting to see some gray. So I really am getting a little bit older. But for the people listening, that's really important because this is all I've done. I've got a lot of information that I can share with you. Whether you have a trust already and you're trying to understand what kind of a trust it is, if that trust works correctly, whether or not you should have a trust, and sort of the component pieces of that trust. So let's get started. So first, it's really important when we get to trust to talk about the overlay of tax in the estate world. So just like for individuals, there is a tax component when someone passes away, both at the state level and the federal level. So for Pennsylvania purposes, we have the Pennsylvania inheritance tax. So it depends on who receives the assets, what the tax is. So in Pennsylvania, if I were to give my assets to my children, it is taxed at right now a 4.5% tax. If I want to give my assets, let's say to my sister, that's a 12% tax. If I want to give my assets to my boyfriend, that is a 15% tax. For New Jersey purposes, New Jersey a few years ago had to actually two death taxes, the estate tax and the inheritance tax. In 2018, that estate tax went away. And now New Jersey also only has the New Jersey inheritance tax. But any asset that goes down to children, to a spouse, is exempt from that tax. So a lot of times we may or may not even have to worry about that New Jersey inheritance tax. Now let's talk about that federal overlay. So for federal purposes, the death tax is a whopping 40% tax. But we have a federal estate tax exemption, which means if you have under $12.92 million, you don't have to pay that federal estate tax. And if I give, even if I have $20 million, if I give it all to my spouse or give it to my spouse in the right kind of a trust, there's something called an unlimited marital deduction. So between spouses, we can pass those assets without incurring the federal estate tax. Then there's also a lifetime gift exemption. That exemption is the same number, $12.92 million. And only over that do we have to pay a 40% tax. Now you might say, okay, I'm listening to this presentation. I want to learn a lot about trust, but I certainly have under $13 million. And the answer is that exemption from the Tax Cuts and Jobs Act of 2017 is sunsetting at the end of 2025, and it is reverting back down to 5 million. So a couple life insurance policies and a house, and we could have that many assets. And then your estate could be subject to that 40% tax. And remember, this is the exemption today. It could change to even something lower or higher. Today, we're not really going to talk about the generation skipping transfer tax, but I just want you all to understand that there's yet another tax involved when you pass away. If you give things down to successive generations, as in I give my assets, I create a trust for my grandchildren, that implicates the generation skipping transfer tax, and that's an additional 40% tax. So depending on who I give my assets to during my lifetime or at death, there are a myriad of different tax implications that we care about. And again, I'll stop here for a second and say, let's say we're under all of these exemption amounts. And we're thinking, well, I wonder if I'm under all of these exemption amounts, what do I care about the tax? So maybe I don't need a trust. And the answer is, a trust can be for the most unsophisticated person to the most sophisticated person's estate plan. And what I mean by that is every last will and testament I draft, now I'm sure there could be some exceptions, but every last will and testament I draft, I absolutely want to include a minor's trust. Maybe has nothing to do with any tax considerations. If I have a minor child, I do not want them to inherit a large sum of money at a very young age without any protections put in place for them. So as simple as having a trust for a minor, even if your children are the age of majority, we still want that minor's trust, because if a child passes away and leaves a child, then we've got a grandchild. So we want to make sure we have a trust in place. Maybe we're looking for that creditor protection, that marital protection, maybe even spendthrift protection, like a minor child who doesn't have that financial maturity yet. Let's set up a trust so that we can have somebody manage the affairs of the trust, work on the investments of the trust, help teach the child some financial maturity so that when ready, we can hand those funds over to a child and they can make really great decisions with those assets. So again, there could be a reason that we have a trust that doesn't have anything to do with tax considerations, but we're going to talk a lot today about some tax considerations. Now, the annual exclusion from gift tax, this is really important. $17,000 each and every person you can give to in this world, $17,000, and not pay any gift tax or have it come off your federal estate tax exemption. So that can be really helpful when we're thinking of how do we transfer money to other people, or how do we move money in a way so that we don't have to pay this 40% tax that we're talking about, Whitney, or even this 12% in inheritance tax for state level purposes. Just remember, for Pennsylvania purposes, there is no exemption. So whether you have $1 or you have $10 million, you are subject to the Pennsylvania inheritance tax. The DSU number, that's called the deceased spouse's unused exemption. That's something called portability. I had this come up in some previous webinars. I've also had a lot of situations where I have a surviving spouse who reaches out to me They went to, let's say, a general practitioner. The general practitioner said, all the assets are going to automatically come to you. There's nothing that we need to do. We don't need to raise an estate or do anything. And they never discussed portability with a client. From 2012 forward, we have something called portability, which means if I pass away today, I have $12.92 million that I can shelter from that federal estate tax. But if I die and do nothing, that exemption goes away with me. Well, this portability has come into play that says, if you file a federal estate tax return, a Form 706, we can take Whitney's $12.92 million and port it over onto her surviving spouse so that we can exempt almost $25 million from that tax. Well, I'd like an extra $12 million to exempt from that 40% tax, and so probably would you. So that's probably the first big takeaway to get from this Trust 101 conversation, which is, if you don't know what portability is, ask your estate attorney. If you have a spouse who has recently passed away, make sure that you shouldn't be electing portability. So now we get to the history of the estate tax. So here comes my very first question for us. Let's see if anybody can get this answer or look it up on the internet really quickly, which is in 1797, that was the first version of the estate tax. Does anyone know why Congress enacted it? What were we trying to do in 1797? And I'll wait a second to see if anybody can come up with the answer. Maybe just one more second. Maybe you guys will get the next one. So it was in order to fund the American Navy. So we had it for the American Navy, and then it was abolished. And then it came back in 1869 to fund, let's see, to fund what? In 1869, what was going on that they could be funding? Well, we've got somebody who answered the question, and that answer is correct. I think he might have even put that before I asked the question. So you might have been thinking about that for the last one. But it was to start the American Navy in 1797. But in 1869, it was to fund the Civil War. And then again, it was abolished. And then it came in 1916. In 1916, it came again, and it has been here ever since. What was going on in 1916? Does anybody know what was going on in 1916? What were we right in the middle of? Yeah, all right. We've got a correct answer here, which is World War I. So in 1916, it came into being and has not been abolished thereafter. So from 1916 till today, we have some form of federal estate tax. In the 70s, we unified the gift and estate tax. We don't have to worry about that too much, but if we have a trust from a very long time ago, it might have slightly different rules and rules regarding taxes than it does today. So if you're looking at a very old trust, there might be some other things we need to think about. And then again, we talked about in 2025 that gift, that federal estate tax exemption is going to go down to 5 million. And so you might say, again, why does this really matter to me? And the answer is, think about it. In the early 2000s, this tax was a 55% tax, and you only needed a little more than $500,000 for that tax to come into being. So just keep in mind, this could be a tax that's implicated in your estate, in your parents' estate, in your aunt or uncle's estate. So it's something that we definitely want to be aware of. And sometimes we do advanced planning with trust on account of this. So again, what is a trust? This is really important. As we talk about a grantor trust, let's figure out what is a trust. So a trust is this fiduciary relationship, which a trustor, that's also sometimes called a settlor or a grantor, gives another party known as the trustee the right to hold title to property or assets for the benefit of a third party. Again, it's generally associated with wealthy, but it can be a very versatile instrument that can be used for lots of purposes. Again, that minor's trust. What if we're trying to benefit a charity and our family members? A charitable trust. What if we're trying to benefit grandchildren? It might make sense to have a trust. So there's lots of different kinds of trust, but they fit into one of these categories. It's inter vivos or testamentary. Does anybody know what inter vivos means? Give you guys a second to see if you can figure out. I took 6 years of this language, 6 whole years of this language. Inter vivos. So let's see if we've got, does anybody know? There you go. Yeah, it means while alive. It's Latin for meaning I create this trust during my lifetime. So you can create a trust during your lifetime, or you can create a trust upon your passing. That's called a testamentary trust. And that can be underneath your last will and testament or your revocable trust. And that brings us to the next section, which is the trust can either be revocable or irrevocable. So revocable means it can be changed at any time. Irrevocable means you cannot change it. And then we get to the last grouping, which is it's either a grantor trust or a non-grantor trust, which is really important. And we're going to learn why it is so important. So remember, the law, the overlay of law that affects trust is the Uniform Trust Code. It's a model law here in the United States. And although it's not binding, it's influential on the states. And as of a couple of years ago, 34 states have a version of the Uniform Trust Code. So that's the overlay of law we have to look at regarding these trusts. For Pennsylvania purposes, it's called the Uniform Trust Act. That's inside of the PEF code, the Pennsylvania Estate and Fiduciary Code. That's in Chapter 77. New Jersey also has a Uniform Trust Code that's in Chapter 31. And New York in their EPT has it in their Article 7. So that's really important. Now you might say not important to me because I'm a consumer. It's the lawyer who's going to know the overlay of the law, but it might be important to you. If you're acting as a trustee, what's the law that you have to make sure that you're following? Well, here is that particular law. So again, trust history. Here's a picture of those Romans. We can go back all the way to 800 AD, the Roman Empire. Romans went to war. Women, children weren't allowed to own title to real property. So they would give that property to a trusted friend. That trusted friend would manage that real property for the benefit of the spouse and the children. So that sort of began sort of the trust. And now that came over here into the United States when America was colonized. And in some version, it is still here today. Now, we used to have grantor trust rules because everybody tried to put assets inside of a trust because trust had a better income tax rate than individuals. So we actually had these grantor trust rules created to make that stop. And now we actually have the opposite problem because a trust pays the highest marginal tax rate at only a little more than $13,000, whereas for a married couple, that's almost $650,000. So we often don't want the income to stay inside of a trust. We might want it to go back to someone else so that we're paying less income tax. So that matters a little bit. So what is a grantor trust? So now we dive into this grantor versus non-grantor. So a trust that's created as a grantor trust, when a grantor or another person is treated as the owner of the trust income or the trust principal or both. And that's underneath Internal Revenue Code section 671. And the reason that we care is both for an income tax component and an estate tax component. Do we have a completed gift? Do we want this trust to be included in the grantor's estate or not? Do we want this trust included in the grantor's income or not? And then we have this Revenue Rule 8513, which is the transfer of assets between the grantor and a grantor trust is a non-event for federal income tax purposes. So it's not a sale. So we want to make sure if the grantor puts money inside of a grantor trust, there's no income tax, there's no sale happening right now. So that's really important to know. Again, for Pennsylvania purposes, they don't follow the federal rule, and all grantor or non-grantor trusts are taxed, so they have to file a 1041. Remember, there's the PIT tax, that 3.07%. And oftentimes, when we have a grantor trust, we are trying to accomplish an estate freeze technique. So here we've got what creates a grantor trust. So first, let's give a really easy example. So when I create an estate plan for individuals, that plan includes a financial power of attorney. So somebody can make financial decisions for you if you can't make them for yourself. I create a medical power of attorney. So somebody can help you make medical decisions if you can't make them for yourself. A living will or some form of advance directive so that you can give direction on what you do or you don't want at the very end stage of your life, whether or not you're an organ donor, whether or not you want to be cremated or buried, all of those issues, including this last will and testament, which is the document that says what happens with your things and who's in charge of it. But we can also do that planning through something called a revocable trust. A revocable trust is a grantor trust. It's a grantor trust because it has the power to revoke, which is created by the Internal Revenue Code section 676, the power to revoke. That is a grantor trust. The grantor can be the settlor, the grantor can be the beneficiary, and the grantor can be the trustee. So you could have all of the roles of a trust being done by the grantor. But here I'm going to explain some of these other powers to get grantor trust status. The power to control beneficial enjoyment, that's in a grantor trust. A grantor trust, we put everything in it and the grantor can take it back out or use it anytime they want. There are a bunch of exceptions to that rule. We could have some administrative powers. Again, most all revocable trusts have that power to revoke so that we can change it anytime we want. We've got section 677, income to or for the benefit of grantor. At section 677, we've got the grantor trust to someone other than the grantor. That's a crummy power. That's inside something we're going to talk about a little later called the irrevocable life insurance trust. We may need that power in order to get some additional preferential income tax treatment. And then, of course, we have a foreign trust with U.S. beneficiaries. And you might say, well, what does this really matter? Whether or not we've got these powers for grantor trust status, we just look and see if we have it. Well, it can get a little bit more complicated than that. And we're going to move to that next complication, which is sometimes we have a revocable trust. And why do we have a revocable trust? Well, we've got a revocable trust here in Pennsylvania to avoid probate, to keep the court system not involved in the estate administration of that individual when they pass away. Let's say we have assets in multiple states. We may want a revocable trust. It avoids all those ancillary probates. Maybe we have an elderly individual where it makes a little bit more sense to put all those assets inside of a trust and have a trustee manage them. So it's a little bit harder for, let's say, someone to access those funds and do something they shouldn't, or even that individual access those funds and do something they're not supposed to. Grantor trusts are a little bit more private. When you pass away, your will is public record. A revocable trust is not public. So if we have something private underneath your plan that we don't want other people to know about, an example of that could be a special needs trust for your child. Maybe your child is high functioning and you wouldn't necessarily want the world to know you've created a special needs trust for that child. We may put it in there. Famous individuals maybe want a revocable trust, so things are a little bit more private. And again, if let's say you're disinheriting a beneficiary, we may want a revocable trust because it is a little bit harder to challenge a trust than it is a last will and testament under the laws anyway of Pennsylvania. May not be all states anyway. Well, so we've talked about if it's a grantor trust, if it has these powers on the page before, if it has all these control powers, that trust that we have is a grantor trust, which means the grantor, the individual who created the trust, pays income tax on the assets inside the trust. That's for income tax purposes. And a grantor trust is not a completed gift for federal estate tax purposes. So those assets are included in the grantor's estate for state level and federal estate tax. That's okay. For a revocable trust, that's what we want. But what if we create a trust where we don't want it included in the estate for federal estate tax exemptions so that we don't have to pay that 40% tax? But maybe we want the grantor to continue to pay the income tax because it's taxed at a lesser rate, or so that we can transfer more assets to the beneficiaries without using up that $12 million exemption. So that brings me to the intentionally defective grantor trust. That is known as an IDGIT. So the trust that you have that you may be looking at, you may say, oh, yeah, absolutely. This is a grantor trust, so it's in for income tax purposes, and it must be in this individual's estate for estate tax purposes. Maybe you're the trustee of this trust and you're trying to understand the rules, or you're creating a trust and you're trying to figure out what kind of a trust would be best for myself or my family members. And the answer is this is where it gets a bit complicated. Maybe we want this trust to be a grantor trust for income tax purposes, but out for federal estate tax purposes. So how do we do that? So these safe powers, if they're included, keep it as a grantor trust for income taxes, but it's defective in granting that estate tax inclusion. So it's out for federal estate tax purposes. That can be really, really helpful. So here we've got some sections of the Internal Revenue Code. Always love to talk about the Internal Revenue Code, especially at lunchtime, put you to sleep a little bit. But just it's important to sort of understand the laws, the regulations, the codes, the statutes that go behind these documents. I can't tell you how many times I have clients say, well, that's just boilerplate language. You just have a boilerplate form that does something. And the answer is, unfortunately, it's a lot more complicated than that. And there are a lot of adverse consequences that can easily occur if we have a trust that wasn't created correctly. If we don't do it correctly and we move $5 million and it's in for estate tax purposes, we may owe a 40% tax on those assets that we didn't need to otherwise. Maybe we're including an asset for income tax purposes to a grantor who can't afford to pay that income tax on an asset that is not their asset. So it is very important to understand what kind of a trust you have and the ramifications of that trust. So here are these safe powers. We've got the power to add charitable beneficiaries. Sometimes I have an IDGIT that has this power, but the client has to be charitably motivated. And oftentimes people create trusts for their family members, for their children, grandchildren, spouses. So we might not want to give that money that we're giving to a child to a charity. So we might not want to include that power. There's the power to make loans to the grantor without adequate security. This one can be a little tricky because if we have different rules or we have trustees who are maybe adverse or non-adverse, it can actually bring that asset possibly back in for federal estate tax purposes. So we don't use that as frequently. Oftentimes we use this thing called the power of substitution. So if you have a trust and it's an IDGIT, you want to make sure that you see this power inside the trust. And this is under section 675, section 4 of the Internal Revenue Code. There's also a revenue ruling in regards to this from 2008. That's very important. This power to substitute property that allows this grantor income trust income tax treatment, but it's out for federal estate tax purposes. And then we have this power to use income to pay premiums on insurance on the life of the grantor or the grantor's spouse. That's really important because one of the kinds of idiots we create is something called an irrevocable life insurance trust, where we put life insurance inside of a trust that's then out for federal estate tax purposes. So we can fully shelter whatever is in that trust from a 40% tax forever, and maybe not even use up any of our $12 million exemption. And again, maybe going back down to that $5 million exemption. So I'm going to pause here for a second to just see, do we have anyone who has any questions so far about what a trust is, the laws regarding the trust, the history of the federal estate tax or the state death tax, what exactly a grantor trust is, and why you may have a grantor trust. We might have it because we have a revocable trust where we want those assets to be able to be freely taken back and forth by the grantor. We may have a non-grantor trust because we want to give away those assets so that we don't pay any tax on those assets when the grantor passes away. Remember, most of these powers need to be exercised by the grantor or a non-adverse party without the consent of an adverse party. So that can be a little bit complicated. We're going to talk about who an adverse party is a little bit later. But do we have any questions so far? I'm kind of throwing a lot of information out at you. Again, you may or may not need to know what Internal Revenue Code section is regarding a clause in your trust. But if you're thinking of creating a trust, we want to understand a little bit about what a grantor trust is, what a non-grantor trust is, why we would have an intentionally defective grantor trust, and sort of the overlay of what a trust is and the background to sort of the tax overlay and the laws regulating all this so that we have the best possible trust for you and your family members, or that you're administering a trust correctly from now into the future. So it looks like I think we're okay on questions for the moment. I'm so glad I had lots of participation to figure out the answers to some of these questions. Maybe I'll have a question or two more. Again, I try to do this Lunch and Learn webinar series. I try to do it about once a month. Sometimes it doesn't happen every month, depending on if I'm in a trial or if I'm not able to do it for a scheduling conflict. Reach out to me anytime. I have some participants that have maybe never missed a webinar series, so thank you for listening. I've got family, we've got friends, I've got clients, I have potential clients. I represent banks and trust companies when it comes to managing these kinds of assets inside of a trust. So glad that you can all participate. Hopefully you get some really good information regarding what a trust is, why to have a grantor trust, maybe even remember about that portability component. And let's keep going. Let's look at, when I'm talking about an intentionally defective grantor trust, let's look at it. Let's look at what is Whitney really talking about, whether it's a grantor trust or a non-grantor trust, right? This is Trust Planning 101. Why do I have a grantor trust, or why shouldn't I have a grantor trust? Well, here's an example. We've got the transferor, that's the grantor. Grantor, I want to give $10 million to my children. I'm over the federal estate tax exemption, and I want to get this asset that is growing out of my estate so that 40% of it doesn't go away when I pass away. So that first section is I pass it through an IDGIT. That's an intentionally defective grantor trust. That means the $10 million inside of that IDGIT is there. And the grantor over here, me, I'm going to pay income tax on that asset that I don't have access to and is used for somebody else. Why would I do such a thing? And the answer is so I can get more money out to the beneficiaries without paying a 40% tax when I pass away. So here if we've got a 5% return over 30 years, then that trust value is 43 million. So we've used up $10 million of our federal estate tax exemption, right? Then we pass away. Let's say we only have $1 million left. We don't owe federal estate tax. And now we've got $43 million. So $33 million wasn't subject to that 40% tax. That is amazing. So that's oftentimes why people use intentionally defective grantor trust. It's an estate tax freeze technique or a way to move money out of your estate forever. Then if we have a non-grantor trust, if we don't have those grantor provisions, and hopefully we're doing it correctly, as in we don't have those provisions that accidentally re-include it so that all $24 million is subject to the federal estate tax, which does happen sometimes when we have a scrivener as in a lawyer who doesn't know what they're doing, creating a trust, or better yet, someone who's on this call who thinks, you know what? I'm just going to go online. There's probably something called a grantor trust online. And I'm going to print it out. I'm going to look at what these provisions are, and I'm going to create my own trust. And the answer is oftentimes that leads to something like this that isn't intuitive. It looks like a trust, talks like a trust, but there could be some really adverse tax consequences to it. But here we've got a non-grantor trust. So we gift $10 million into this trust over 30 years at a 5% interest rate. We have $24 million because the income tax had to be paid by this trust. So we get a little bit less out to the beneficiaries, not subject to that federal estate tax. So you might say, why wouldn't you do an intentionally defective grantor trust? But the answer is maybe the grantor doesn't want to pay the income tax. Maybe the grantor doesn't have enough money to pay the income tax. They feel like they've given $10 million. Trust can pay the income tax. And if they get 24 million that they can shelter from that federal estate tax, that is plenty. One of the things on this next slide that I want to talk to you about that can be really important is some drafting considerations. We've got a reimbursement provision. Sometimes if we put a reimbursement provision, we've got to be careful. Maybe we can reimburse the grantor and still keep the powers that we want to include it or uninclude it in the estate. And we want to remember here as well, it's often a good thing to have an asset held inside of an estate for that step up in basis. We get that from section 1014. So 1014 gives us that step up in basis so that when I pass away, now today I'm in my home office. I often like to do webinars in my home office. It's actually a little bit quieter here than sometimes in the office where we've got a lot going on. But you'll sometimes see me in an office, whether it's in Philadelphia or New York or New Jersey. You might see a different background, but here I'm in my home. So when I pass away, and that home transfers down to my children. Let's say I bought this house for $300,000. If I pass away and it goes to my children, and let's say I did a really good job, I fixed this house up, the market's still up, they're able to sell this house for $1 million. Well, under the law, under this 1014, they get a step up in basis to the fair market value as of the date of death, which means my children do not pay any capital gains tax on that basis difference between 300 and $1 million. They have $1 million basis and they sell it for $1 million. They pay zero capital gains tax. That's really helpful. So we really need to think about it when we're creating a trust. Do we want it included in the grantor's estate for federal estate tax purposes? Do we want that step up in basis? Or do we want it out for federal estate tax purposes? Get rid of that 40%, used to be up to 55% tax. And the answer is each particular situation is different. I will say that basis step up is always on the chopping block. They're always thinking about ways to get rid of that basis step up. But that's a pretty important one for me to talk to clients about if they're under the federal estate tax exemption. If instead of giving this house to my children when I pass away, let's say I just gift it to them before I pass away, the answer is you get a carryover basis so that when they sell that property, $300,000 is their basis. They sell it for $1 million. That $700,000 difference, they're going to pay a large capital gains tax on, maybe as high as could be 25%, depending on what's going on with the laws. So it's really important we want to understand whether or not we want something included in the estate, whether we want something included for income tax purposes or not. And the answer is, can you have your cake and eat it too? Do we have grantor trust status that we toggle on and we toggle off? And the answer is maybe. We've got to be a little bit careful. So sometimes I have clients say, well, I want to create this irrevocable trust, but I want to be the trustee of it. Well, how much do we care about whether or not it's included in their estate for federal estate tax purposes? That's kind of where we're at with relinquishing or turning on those grantor trust statuses. Again, if we give the grantor too much power, we're going to re-include that asset. So the less power that we give to the grantor can often be better, but we might still want to include it for income tax purposes. So we want enough powers so that we get that income tax inclusion. So here we're explaining some of those provisions that you may or may not see inside of your grantor trust and the concerns we have related to those powers for whether or not it's included in your estate or it's not included in your estate for that step up in basis or for that federal estate tax exemption. So that leads me to trustees. We talked a lot about grantor trust status. That's the person who creates the trust. That's the settlor. That's the trustor. That's the grantor. But what other people are involved in a trust? Well, we've got a beneficiary. A beneficiary means the person who gets the money. That's the beneficiary. That's the person who's being benefited. So that minor's trust that I create, let's say I created under my estate plan for my child. I have 2 minor children. I have an 11-year-old and I have a 16-year-old. So I've got a minor trust under my document. I pass away. First, is it an inter vivos trust or a testamentary trust? Can anyone answer that question? Is the trust that I create under my will for my children, their names are Patience and Paolo, is that trust an inter vivos trust or is that trust a testamentary trust? And it looks like we've got an answer. Let's see, do we have it right? Absolutely, that's a testamentary trust. Inter vivos means I created it during my lifetime. I did not create it during my lifetime. It's created under my will. And my will doesn't come into being until it is probated in the court system. So I've created that trust for my children. They are the beneficiaries of that trust. But then what happens? So I have a will, I've got a trust for my children. I pass away, it goes into this trust. How do my children get money from this trust? What happens with this trust? And the answer is the trust says what happens with these assets, and it's the trustee. So this third role, which is we had a grantor, we have a beneficiary, and then we have a trustee. And the trustee is the person who is going to manage the assets inside of this trust and make distributions to or for the beneficiary pursuant to the trust document or the laws surrounding the trust document. So it's really important who we pick as the trustee. We can have an individual as a trustee, and we can have a corporate trustee. And that's a question I get a lot, which is, should we have the same person act as the grantor as the trustee? Again, maybe we care whether or not we want estate tax inclusion or not. But again, a lot of those powers have to be granted by the grantor or a non-adverse party without the consent of the adverse party. So an adverse party is somebody who is substantially interested in this estate, and they're affected by the exercise or non-exercise of a power possessed by such party, right? So that's under section 672A. Non-adverse party is anybody else. And then we also have a related or subordinate party. So that could be the grantor's spouse, the grantor's parents, children, brother, sister, an employee of the grantor, a corporation, or any of the employees. It could be a subordinate employee of a corporation, which the grantor is an executive. So we need to be careful who we pick as the trustee, what powers we give that trustee, and what those powers do to those grantor trust provisions. And I was just looking back at the questions, and I think I had somebody answer that we've asked one of these questions before, and I've answered it, which is awesome, which means you're listening. So we want to make sure, we're not trying to trick you in these webinars. I want to give you as much information as humanly possible. I want you to know the answers to these questions so that you have the correct kind of trust, that we have it in for estate tax purposes or out for estate tax purposes correctly. We have it in for income tax purposes or out for income tax purposes correctly, that we have all of the information that we need in order to have the right trustee for the right trust for our family members. So grantor trust, these intentionally defective grantor trusts, we already talked about having something called a revocable trust. That's a way that we can avoid probate. Many states, we care about that more than less. Florida has higher probate fees than Pennsylvania. So maybe in Florida, we have a revocable trust, maybe not in Pennsylvania. In Delaware, we have high probate fees. So maybe we have a revocable trust in Delaware. Maybe we have some of those other tickers that we've talked about, having lots of property in lots of different states. Maybe we want to keep things more private. Maybe we're disinheriting somebody and we see litigation on the horizon. We may want to use that revocable trust, and that's a grantor trust. The income tax will be paid by the grantor, and that revocable trust is also going to include that asset in that individual's estate, so they get a step up in basis on those assets. So we've talked about that revocable trust, but what other planning could we have? What other trust could we have for this advanced planning? Well, we've got that irrevocable life insurance trust. We talked about that before. It's also called an ILIT, where we create a trust. We have the trust by a policy on the life of the grantor, and we have the beneficiary of that trust be the trust. That way, let's say I have $5 million life insurance. I create a trust. The trust buys this $5 million life insurance policy on my life, and the beneficiaries of the trust are my children. And the beneficiaries of that life insurance policy will be this trust. The trustee, I have a local bank who's going to make sure all the fiduciary requirements are met and distributions are made to or for the benefit of my children. $5 million won't come off my exemption, and $5 million I get to transfer without paying a 40% federal estate tax. So ILITs can be awfully handy. I feel like we've done less and less of them over the years as the exemption has gone up. Now that the exemption is going straight back down, I foresee that we're going to see a lot more ILITs. A grantor retained annuity trust. Here's my last question, and I haven't asked this question before. Here's my last question of this webinar series today, which is, what famous family first tried to use this technique of a grantor retained annuity trust, also known as a GRAP? I'm going to give you a second to see if you can think about it. It looks like we've got somebody who's already answered this. We don't have the right answer yet, but I love the participation. It looks like maybe we've got another one who come in. There we go. That's right. So this was first used by the Walton family. The Walton family were the owners of Walmart. So what they tried to do was create a trust to put Walmart stock inside of that trust so that the growth, so that when Walmart stock went up, that growth was out for federal estate tax planning. All of these advanced planning techniques are estate tax freeze techniques. And the idea was we were going to put the shares of stock inside this trust. We had to make annuity payments for a certain period of time. That's called a zeroing out that grad. Have that money paid back to the grantor so that the amount that we put in, let's say we put in $10 million of Walmart stock, the grantor then got $10 million from this trust. So we zeroed that out for federal estate tax purposes. And now this Walmart stock, when this individual, when the settlor of this trust passes away, is worth $50 million. We get $40 million that is not subject to a $40 million tax. So GRATs can be very beneficial to individuals. So great, that's right. Maybe look up the Walton family, see what actually happened with their trust, because it didn't actually do what they wanted it to do, but it led to the ability for us to do that. Then we've got something called the Qualified Personal Residence Trust. That's called a QPERT. Oftentimes when we have something like a family beach house that we bought for a little bit of money, that again, the market is rising and we want to have there for our family for future generations, we might move that beach house into something called a QPERT, which is again an estate tax freeze technique, so that the growth of that asset is out for federal estate tax purposes. Charitable trust. Lots of different kinds of charitable trust. We can have a charitable lead annuity trust. That's called a CLAT. We can have a CRUT. We can have a CRAT. We can have lots of different kinds of charitable trust that could be intentionally defective grantor trust. So again, in for income tax purposes, out for federal estate tax purposes. It's really important to know as well, grantor trust, they can hold business interests, S corporation interests, QSSTs, ESBTs. It's important to know that a grantor trust can hold all of these type of assets. So it's really important to understand, one, do we want a grantor trust or non-grantor trust? Or if you have a trust, do you want a grantor trust or a non-grantor trust? And what are the ramifications of that? So we're in the last couple of minutes of my webinar presentation. I'm going to ask if anyone has any questions. Do we have any questions about what a trust is, the history of a trust, the law behind a trust, what qualifies as a grantor trust, what qualifies as a non-grantor trust? Why in the world would we have an intentionally defective grantor trust, something called an IDGIT? Any questions regarding that advanced planning? Do we want an ILET? Do we want a GRAT? Do we want a CLAT? And what kind of assets can we put into that trust? And how does that affect our estate for that basis step up or carry over? What does that do for the federal estate tax, whether it's in the estate or out of the estate? So here we've got a question that says, do people seek second opinions on their trust plans? That's a really great question, which is absolutely. If you've created a trust a long time ago, it is really important to have that trust reviewed from time to time, whether with whoever created that trust, what firm created that trust, or someone else, to make sure that that trust works the way we want it to work. If it's an irrevocable trust, maybe it's less about changing provisions in the trust, but understanding how it works so that we have it work in the best possible way. Or if we have created a trust that can be changed, should it be changed to account for changes in the law, like the federal estate tax exemption being lowered? Normally what I tell my clients is every 5 to 7 years, you want to look back at your estate plan that includes a last will and testament, that financial power of attorney, medical power of attorney, living will, and all of those maybe testamentary trust under your plan, or some of these advanced trust techniques like an eyelet, like a grat, like a cupid to make sure that we're managing those assets correctly. One of the main problems I have with eyelets is beneficiaries, the grantors of the trust, forget to give out crummy power letters, which is important to keep that asset, the assets that are inside of the trust, if we're purposely keeping them out of your estate for federal estate tax purposes, we don't want to accidentally re-include them. And sometimes trustees, grantors, beneficiaries do that, and it creates something like a 40% tax problem. So really important to do that. The next question, and I didn't say this earlier, is what happens with these slides? Great question. So we have a recording on our webpage where you can view all of my webinars, and we send all the participants, all of the people who are on this presentation, we send you the set of slides so that you can look back on them. Of course, you can always reach out to me. My name is Whitney O'Reilly. You can shoot me an email. You can give our office a call if you ever have any questions. Certainly feel free to ask. The next question is, do trust plans cost a lot to create? That's again, another really good question, which is no. I mean, in every estate plan that I create, I have a minors trust for family members inside of that trust. And that's people that have a house and a bank account. And that's people who have $100 million. So a trust certainly can be reasonable. I do charge more when I create a revocable trust versus a last will and testament model. So you'll certainly want to ask your attorney the cost of a trust plan to create some of these advanced trust planning techniques. I often charge a flat fee, so I'll let you know what that fee is, and then you can determine whether or not it makes sense. Many other estate practitioners do the same thing, but it's always a question to ask the attorney that you're working with. How much is this thing going to cost me? Because if it costs $20,000 and I'm only getting a saving of $10,000, does it make sense? I need an estate plan, but I don't have millions of dollars. I can pay a few $100s. I might not be able to pay $7,000. So to have that understanding can be really important. Another question, would intentionally defective grantor trust be used for any other reason than to remove assets from your estate for tax reasons? No, but we create trust for lots of reasons that we talked about before, which is creditor protection, marital protection, spendthrift protection, because we have a minor child who can't handle the ability to financially manage, let's say $1 million if mom and dad passed away. We might not care about those tax considerations. We might not care whether or not it's a grantor trust or a non-grantor trust, whether it's defective or not defective. But yes, the reason that we create that defective powers is because we maybe want it in for lifetime reasons and out for death reasons. And again, remember when we initially had these grantor trust rules in place, it was because people were trying to move the income tax consequence to the trust because we had better income tax inside the trust. Today, the answer is the exact opposite, which again leads me to why once in a while we've got to look back at your plan and make sure that we've created the right kind of documents. The next question is, do trusts need to file annual tax returns? Absolutely. This happens all the time where we have a trustee of a trust and they don't file tax returns for a number of years. Interest, penalties accrued, and that trustee is sued for not managing that trust correctly. So remember, we've got to file those annual trust tax returns. If it's a revocable trust, it's often just on your income tax return, depending on the state that you live in. If it is not a grantor a grantor trust, then it's going to be a separate trust income tax return. So yeah, you certainly want to talk to your estate team, including your accountant, to figure out whether or not you have to pay tax on this asset during your lifetime or at death, and what, if any, tax considerations there are. So do people create and maintain separate trusts for both business and personal reasons? Absolutely. Part of business succession planning, and we'll do a webinar regarding business succession planning, is we oftentimes move a business to successive generations through trust for that creditor protection, that marital protection, that spendthrift protection, and that tax protection. So absolutely. Is the trust administrator the same as a trustee? That's a good question. How do you find a trust administrator? So oftentimes we use different words interchangeably. A trust administrator oftentimes is the trustee. Sometimes we have some different roles inside of a trust, like a trust protector or a trustee who only deals with distributions, or a trustee who only deals with income tax payments. So we've got to read that trust to make sure we understand who are the acting individuals. And then how do we find that trustee? The answer is it can be a family member, it can be a friend, it can be a bank, it can be a trust company. It can be an individual or a corporate person. And there's a lot of considerations between those two. So I recommend you speak to your estate counsel to determine who is the best fit. If I have a trust in place for my minor child, but I only have a couple $100,000, maybe I just want it to be their family member. Maybe they get a little less creditor protection by having an interested trustee. Maybe they don't. If I have a trust that is millions of dollars in it and it is an islet, maybe I don't want someone closely related, like a subordinate employee, because it might re-include those assets into my estate. So there's a lot of considerations we have to think about of who the trustee is going to be. And the next question is, are you available to review a client's trust to help determine the type of trust and what the tax consequences are? Yes, absolutely. So that's what wealth preservation departments do at law firms, is absolutely, we review trust to help whoever, let's say, is acting as the trustee understand the tax ramifications so that they're doing what they are supposed to be doing. So that's often what our department does for institutional clients, like accounting firms, like banks, like trust companies. And then should trust be created to try and serve multiple business and personal objectives at the same time? That's a great question. So underneath my estate plan, I already told you I have 2 children, and we'll end with the answer to this question because I know it is 1 o'clock. But thank you so much for participating, everybody. Lots of great questions today. But underneath my estate plan, I have a minor's trust for my children. I have 2 children. I have 2 separate trusts created for each of my children. They are siloed trusts, so that 50% of my estate goes to my son, 50% of my estate goes to my daughter, and they're not connected to each other. They may have different trustees or the same trustees. They may have different distribution standards. They may have the same distribution standards. They may say what happens when the trust passes away. It could be the same or different. There's lots of reasons that we want to create separate trusts for each individual or each asset. And there could be lots of reasons to create something called a pot trust, where that pot trust does a lot of different things at the same time. I'm often a little bit more of a proponent of separate trusts, but a long time ago, people were proponents of the pot trust. So there's, and that's not for marijuana, although I guess you could put a marijuana business inside of a pot trust. But the laws change and things can be favored or not favored. So again, I'm going to end this webinar. I try to do this once a month. Again, thank you so much for asking all of your questions. My name is Whitney O'Reilly. I'm the Wealth Preservation Chair of our Wealth Preservation Chair of our firm here at Cohen Seglius. We deal a lot with trust planning and trust administration. If you have any questions moving forward, feel free to reach out. And hopefully I see some of your names on an upcoming webinar. And for the few people who answered correctly a couple of those questions, I'm going to send something out to you. So if you don't get something in the next couple of days, let me know. And join again. I give great prizes, and hope you learned something, and have a great rest of your day, everybody.